Hey, lady, how are you? Good to see you today.
I'm good. How are you, Sabra?
I'm good. I hadn't seen you in a while. What you been up to besides working with Mr. Josh?
No- nothing much. Trying to stay busy.
Well, that's a good thing to do, especially if it's busy being working.
Yeah.
I was having trouble getting on Zoom. I don't know why. For whatever reason, it was stalling me today. So I hope we'll be able to do the class and not have too much difficulty. Have you done some South Carolina listings yet?
It has been a while since I've done a listing in South Carolina.
Okay. Well, that's probably why you're on call today, right?
Yes, that's correct.
That makes sense. That makes sense. Hopefully there's not too much change on the listing side. We did have some changes in forms on the buyer side, but I believe where you're pretty well. If you've done it before, this will be a refresher for you. But we'll hopefully it'll be beneficial for you. Do you think you're going to be in? You're anticipating some more South Carolina business now?
Oops. Hold on, Sabra. I know it. Yeah, I am, Sabra. My screen went away.
Oh.
Yeah.
Oh, I tell you what, technology. Well, a while ago when I couldn't get on the Zoom, I went, "Oh no, this is not a good thing." Sometimes the screen goes away. You never know what's happening on the background, do you? At least I don't. Okay, but we'll wait a couple of minutes and see if some others join us, and if not, we'll just proceed forward.
All right. Sounds good.
Are you getting some leads now from Op City?
I am. I'm getting leads from Op City. Actually, I have a closing coming up here real soon with Op City.
Do you?
Yes,
Good.
I do. Yeah.
Good. Well, you're in as I think as an experienced agent, aren't you?
Yes.
So that you can narrow down a little bit the radius that you work in and your price point. That
Yeah,
really
a little
helps
bit.
you do that. Yeah. But sometimes we want to broaden our radius in order to get some more leads.
Right.
I haven't seen the leads being excessive lately.
No, they haven't been. Yeah.
I've been surprised, but I guess you have that app set on your phone, so it's set on go. So if you see
sure
something,
do.
Yeah,
I sure do.
that's good. That's really good. Well, let me see if I can get our forms up. Okay. Sometimes I lose you, but I'll try not to. Hold on.
All right.
All right, hang in there. Okay, let's see. I think I have to do this. No, that's not what I want. I gotta get my forms first. Sometimes when I get my forms first, then it doesn't come through, and other times I have to do the Zoom first. Let's see. There they are. Let's see. And North Carolina listing. Okay, now let's see. Okay, now let's see if I can share them. I found the forms. Looky there, looky there. We're doing good. You're a good luck charm today. Okay, can you see the forms?
Yes, I can see them.
Oh, wow. I need to write that down. Whatever I did worked. Okay. Now, I'm presuming you already have gotten your South Carolina, the membership in the South Carolina Realtors Association, so you can get the forms
I do, yes.
I figured you must have had that. So that's where I always have to start, because there are a lot of newer agents that don't know to get that. So let's scooch on down through there. And this, of course, is going to be your number one form. In South Carolina, it's the disclosure of brokerage relationships, which compares to our working with real estate agents, as you well know already. The main thing on this, I've highlighted some of these things. By the way, I can send these forms over to you too, so that you will have some of the highlights if you want me to.
Okay, that'll be great.
Would be good. Okay. In this form, the main thing that you want to concentrate on, and I really like this part of their form where it starts out here with, you are a customer, you can become a client, and then it's your choice. I really like that. It's a simple outline so that when you start with the words customer and client, there's not too many people that don't have a concept of what a client is versus a customer, but it's nice to use those words, when you're describing how you work. And again, this disclosure it's how you work or how we work as a firm. Okay. It's not anything for them to make, for them to be aware of that they could be scared of. It's just a disclosure. And as we do on North Carolina and South Carolina, right here, this little phrase, this document is not a contract. That's obviously everybody's so afraid right at first that they're going to have to start signing contracts. And that truly re-emphasizes the fact this is just you telling them how we work. And then you're going to get their signature that you've done it. That's all this form is about. And when you're talking about being a customer, again, you don't want to spend an awful lot of time on this, but you want to help them to understand that primarily as a customer, you can't share an awful lot with them. You can share anything that's public knowledge, but you basically are not representing them at that particular time. And in South Carolina, they do offer something called transaction brokerage. And when I say they, I'm saying it is a viable way of doing business for some firms. The firms can decide if they will work with a person as a customer. And our firm has decided not to. A few years ago, when this first came available, our firm decided that we would continue to work only on an agency relationship. We do not do the fee for service, which is basically what a transaction brokerage is. You're not going to take care of them as a customer, because we do not accept that type of form. And that's your disclosure to you, the person who has the choice of being a customer or a client. As of course you're discussing being a client, the main thing you want to highlight is this: the fiduciary duties, that if they are a client of yours, you do owe these fiduciary duties. And you remember in pre-licensing the acronym old CAR, this is just spelling it out in a sentence form of the way you're going to work with them if they choose to be a client, not a customer. We work with them, obviously, just representing them. We can work with them representing both sides, them as a seller and a buyer, or vice versa. We can work with them as an individual dual agent, which if you're working both sides, you would be the individual dual agent. But the dual agency term applies most to the firm. And we're not going to go too much more disclosure or discussion on it until we get into the listing agreement in a few minutes. Down here where it says it's your choice, I always go through this list of bullet points because it is their choice. If they want to work as a customer, they would either, if you're the listing agreement, a buyer can be a customer. It would be very hard for the seller to be a customer, because you're not you're not representing them. Now you can bring a buyer and work with them as an unrepresented seller, but most likely that's not going to be the case, because today we're talking about listing the property. Okay. So again, this is not a contract, and you just need to get their signature that you've given it to them, and briefly gone over it. All right. Or be ready to ask any questions. So that is your initial step, obviously. Now, this little section here, this is just an explanation of what I just went through. It's the written explanation that came from the South Carolina Realtors Association, in case that you want to have a little script, because obviously, if we call it our elevator speech, you're going to go through it pretty quickly, but at the same token, because you're not asking for a decision. Okay. Now this, I'm sure you probably already have a copy of these. If you don't, put one handy, because this is the little cheat sheet that I put together anytime there's a change in forms. The titles of the forms in North Carolina and South Carolina are vastly different for the same purpose. So like when we make an offer to purchase, North Carolina, is the title of the form is offer to purchase and contract. In South Carolina, it's called agreement to buy and sell. If you just hear agreement to buy and sell, that makes sense. But when you start trying to correlate it to the North Carolina form, sometimes you don't know what form to ask for or to look for. So I put together this little cheat sheet, and I do keep it updated anytime their form changes. As you can see, we have the form numbers here, and we have the dates that they changed. South Carolina does not have a scheduled update time of the year. They change a form anytime they feel that it's right to change it, and they get the powers that be to sign off on it, really, as they did in June the 13th this year. They changed some of the forms for the buyer side, and that's just an odd date, but that was the date they changed those 5 forms, actually. So the North Carolina forms change every year in July 1. It's rare that there's not some substance change in the forms in North Carolina that go into effect July 1. But if not, they will definitely have format changes. So know that July 1, any year, you're going to see at least the copyright date change. So as you can see, I've got all these on the North Carolina side in July 2022. On the side of South Carolina forms, you will see some old ones at 2017. It was copyrighted in 2020. Yes, that's the current form. Like, I get that question all the time. It's like, oh, it's so old. Is that the current? Yes, it's the current one. So when you're looking up your forms, again, you can look at the number and correlate this to our little list. The grade area here is for the listing side of the transaction, and then it goes on down to about 2 pages on the buyer side. I try to keep the current date here as well. This date was changed, obviously, in July, with the North Carolina forms changing, which then would include those changes that were made 6/13 on South Carolina. Enough of that. Again, that's just a little cheat sheet for you, and hopefully you'll find it helpful. This is our multicolored checklist. This really is a checklist for you to kind of follow along the process of how you're going to do your South Carolina listing. You're going to initially start with what we just did, the South Carolina Disclosure of Brokerage Relationships. Even if you go no further than that, at least have that signed, and you can have a separate opportunity set up in Command for every one of them so that you can follow up with those people, or you can have one folder set up in Command and just put multiple ones in that go no further, because the South Carolina and North Carolina Commission sometimes questions us as brokers in charge if we have those. So you might want to make those, put those in Command so that they're available, or at least you have them. So if I need to come back to you and get them, okay? Now we're going to go into the exclusive right to sell, which is the next document you and I are going to talk about. And all these forms right here are forms that need to be done more or less simultaneously. Once you start talking to them and get the listing agreement, you're going to have one or more of these forms right here in this section. And you really want those to be turned in about 3 days after the seller has signed them. You're not going to submit them for review because we're not quite ready for the review process until you get a few more of the forms, but at least put them in command and get them ready to submit for review. As I said, this is kind of like step by step, the forms that you might be looking at any given step along the process. So hopefully, as I've outlined them through here, it will give you a jog of your memory or thoughts process as to what forms need to be done and or what ones you're choosing not to do at that time. Okay, so basically right here, you also have some steps of receiving the offer. You see where it says here, listing sale, submit for review. You as a listing agent obviously are going to be receiving an agreement to buy and sell, an offer on properties, and hopefully it goes under contract. So if it goes under contract, you're going to have to go back into command in that opportunity and add the paperwork for the listing sale. So we kind of have it all outlined here on this one form. You may choose not to use this form. Sometimes some agents like to have a piece of paper. Others are going to use just what's online in command, which is just fine. Either one, whichever is more suitable to the way you do business. Okay, I put it in here in case you need it. If you don't need it, then just disregard. One of the things I don't like at all is this right here. Terminations. Oh, we do have them. I wish we didn't, but yes, we do. And sometimes it's kind of nice to get rid of some clients because they're so difficult to work with. But that's the only time I say, yes, we like that termination form. And these are the form titles here in South Carolina to terminate. If you're going to terminate just the listing, it's going to be this form right here. Again, I hope you don't have to use them very often, but at least you have it on the checklist if you need it. I don't know why that extra page is in there. I'd like to say I left it on purpose, but I don't know why it's there. Okay, let's talk about the listing agreement. The listing agreement did not change the last couple of years for South Carolina forms. The biggest thing that we have to deal with in the North and South Carolina right now is the beginning time of the listing and the beginning time of the marketing. Now, before I talk about that, let's go right up here just a moment. Let me look with you at this. I mentioned a while ago, the agency agreements are with the firm. They would not be with the firm and an individual agent's name. It is with the firm. Now, the line up here, obviously, is going to be the seller. How are you going to know who the seller is? Well, hopefully it's the person you're talking to, right? Then you're going to find out if that person is married or if there may be somebody else on the deed. You want to obviously put all names that are on the deed because all names have ownership interest in it if they're on the deed. Therefore, you have to have everybody to sign. Now, one of the things that we are seeing so many of this past year, I don't think you were in the business back in 2007 and 8, but back then it was all foreclosures and short sales. I mean, just about every 2 or 3 listing agreement came through not being a foreclosure or a short sale. It's almost similar to that now with estates. We're not seeing foreclosures, but we are seeing so many estates. And so if for what in South Carolina, there's something called joint tenancies in common with rights of survivorship. That means the parties that are on the deed own the property 100% each, because it says rights of survivorship. If it does not say rights of survivorship, if it just says joint tenancy or joint tenants in common, then the people who are names that are on the deed would have ownership as described in that tenancy of in common. Typically, it's going to be 50-50. So that if one of those persons is deceased, the other person only owns 50%. They don't own 100%. So it has to go through probate, and often it will take as much as 6 to 8 months to settle that estate to the degree that that property can be sold. That is different in South Carolina from North Carolina. North Carolina has a default of what we call a marital interest, which is another way of saying rights of survivorship. If a couple who are married own a property, if one dies, the other person owns 100%. They have the right of survivorship. So they then can quickly get through the process of having the right and the ownership to sell that property. In South Carolina, that's not the case, as I described a minute ago. You must make sure, if it is an estate, who actually owns that property before you want to put it out to market it as being able to be sold. Quite honestly, we're going through that process right now with one of our agents, where we're trying to get answers because they're under contract. Our agent is under contract, and the listing agent apparently listed it prematurely without knowing that it was at the stage it could be sold. So therefore, it's going to take a little longer, not sure exactly how long, to be able to sell this property. So that's one of the reasons I wanted to bring it up to you right now. Just be aware, if it's an estate, you're going to have to do some extra research as to who actually owns it and who actually has the right to sell it. Okay, so be right here. Hopefully it'll be an individual or maybe two individuals that their names are in the deeds, and you won't have to do that extra research, but just make sure you do. Now, any contract must have a beginning date and an end date. Okay, so they put the beginning date and the end date right up front. In South Carolina, excuse me, the date that you put right here is the date that you can put the listing in MLS, either as coming soon or as active. That's the date it goes into MLS. That may or not be the date that the listing agreement is signed, but that's the date that you're going to be able to sell it and market it in MLS. Now, I use these dates, and I should update my dates, but when we did this form last year in October, we had the most current listing agreement, which we do right now. So let's say you had your sellers and you sign on October the 10th, but you and the seller have agreed that the term is actually going to start on October the 15th, when you are able to put it in MLS, either as active or as coming soon. And I kind of added that little cheat sheet up here. Then it's going to end at midnight on 2/28. What? 2/22. Okay. So here you're going to have just the date that you actually are going to begin the term of this listing. This is not the effective date. This is the date you're going to market it. Now, let's look at a couple of things from here. If you are going to put it active, there's no reason to go to the other forms I'm going to show you. If for whatever reason you are going to go coming soon, you know that there's another form for that, right? So let's scoot on down here and see this coming soon form. There it is right there. In the South Carolina form, you're going to see, excuse me, not the South Carolina form, for a South Carolina listing, you're going to make sure that there is an active date right here. And that active date is the date that is going to go from coming soon to being marketed active. So the MLS, this is an MLS form, and it has to coincide with the state form, which is what we've been going through on the listing agreement. So make sure that on October the 15th, you must have this form in place that says what date it's going to go active. And let's say it's going to go active on October the 22nd. All right. So when you put it in MLS on October the 5th, on the 15th, MLS asks for a marketing date. That's the active marketing date. And then you would put in October 22nd at that particular time. There is not a place on page 1 of the listing agreement for you to put October 22nd. It's only going to be on the coming soon form. All right. And the way you're going to, oh, wait a minute, let me show you one thing before I go back. Hang on to that thought. When you get the coming soon form together, I have to sign it as the member participant. And look at this form right here. You're going to put the property address. You're going to get the seller signature. You're going to put your signature as the listing agent, and then it asks for member participant. I know it seems like you should be the member participant, but that's not the terminology MLS uses. MLS uses listing agent, which would be you as a subscriber to MLS. The broker in charge of the firm is the member participant. So when you put all these forms in your envelope in DocuSign, you can order or you can designate the order in which you want them signed. The order that you want them signed typically is you signing it first. Then it would go to the seller for the seller's signatures. And then I would be the last one. In most cases, I would be the fourth one. But so go in there and practice on setting the order in which forms are signed so that you get, the sellers can sign it first and then you, but typically you sign it, they sign it, and then send it to me. That form it does stay in command, but if MLS questions me or questions you, we can show that it is signed by the broker in charge. That has to be signed at the time of when you do your listing. It is not, you don't wait 4 days or 8 days or when you turn your forms in to be submitted for review. That's not when I get to sign it. Okay, I'm supposed to sign that within 1 day of your taking your listing. Okay, now let's go back to the listing agreement. Okay, so we've signed, the effective date is October the 10th. October the 15th, we're going to put it in as coming soon. On the coming soon form, we're going to have the date of October the 22nd. As you see, it's not noted anywhere here. It's only on that form. And the end date is is entered in this spot here. Now, when you are going to list any property, one of the first things you want to do is to pull the tax records. The tax records supposedly, or I guess I should say, the most accurate information that we have on the parcel ID, the parcel legal description. Most of that is the most accurate you're going to find. Every now and then there's a discrepancy, but most of the time you're going to find it there. So you're going to fill this section here out based upon the legal description in your tax records. A subdivision name should be there. You might want to put a condominium name there. The condominiums, you can tell if it's a condominium, if it has the word unit in it. Otherwise, it's going to have some land. If it has some land, it's going to have a lot, block, and section. Don't get too concerned about the block and section. One of the main things is to make sure that you have the lot number. All right. This term tax map number, that means the parcel ID. If you are, when you put your listing in MLS, you're going to enter the parcel ID, and that's going to be a hyperlink that when another agent is looking at it, they click on that hyperlink and they go immediately directly to this one property. I'm sure you've already done that because you're experienced and you're very familiar with that, but just make sure that you understand that the tax map number means parcel ID, and the understanding that we use it most of the time. Now, this little section right here in South Carolina, they have one word for fixtures. The word is fixtures. Look at there, right here. All improvements, fixtures, and appurtenances, and the additional property. What is a fixture in South Carolina? Would you believe there is no definition? It's anybody's guess. I guess it's one of those things, what you just know, if it's a fixed, it's a fixture. One of the longtime South Carolina instructors says, if you can turn the house upside down and shake it, what falls out is not a fixture. If it doesn't fall out, it's a fixture. That's well, that gives you a picture in your mind, really, of what is a fixture. So what another Vic and I did a few years ago, a Vic down in Fort Mill, Keller Williams, we put together something called a fixture addendum. They had an attorney in their office, and so they've shared their form with us. Now let me show you that form. It's right on down here. I would suggest, if I were you, I would put it with every one of my listing agreements and or agreement to buy and sell, because it specifies or clarifies what a buyer would be expecting, or what the seller is expected to leave or not leave. Sometimes sellers don't know what to leave, and they think if they own it, they can take it. And if it's affixed to the house, they can't take it. So this, again, this is just a list of the things that you would anticipate being left. If there's something that they don't want to leave any of this stuff, there's a place right here. It says seller does not intend to convey. The seller is going to keep it or take it with them. You want to list these things right here. More than the form is a reminder for you to talk to sellers about it, so that they know that there will be expectations of a buyer as to what will be left in the property. Just recently, we had a discussion with one of the agents as well on it was a fuel tank, and it was a leased propane tank, and they had not discussed it. The agent hadn't discussed it with the sellers, and the sellers thought sure they could take that tank because the tank was leased. Well, the buyer came from another part of the country where they bought their propane tanks. So there was a miscommunication on that. So again, if you will put right here, if it's leased, if it's a propane gas tank that's leased, not owned by the seller, this is where you're going to list it. Very similar. Doesn't it look like the North Carolina list? Well, obviously it was designed from that. So if you have this discussion with the seller early on, and you can even make this fixtures addendum, if you check right up here, it's addendum to the listing agreement, then you want to have that available. You can attach it to the MLS listing so that a buyer's agent will have that to present to the buyer, and everybody's kind of on the same page before you have to have a disagreement on it. Okay. Another one of the things that you want to look at on this one, this is an in-house form. You cannot require a buyer to sign it. I think it would be prudent for them to sign it. That's another reason you want to add it to be an addendum to the agreement to buy and sell, because then it does require a buyer to sign. You are going to get your seller to sign so that you know what the seller's thinking. But anytime we have an in-house form, you cannot require a cross-sell agent to have signators. But in this, if you would put it a part of your listing, you can. Okay, let's scooch back up here now and let me show you. Whoops, way to go, right here. This is where you would add that you are attaching the fixtures addendum. You can add it here, or you could add it under number 28 on this listing agreement, okay? Now, this is where you have your discussion on dual agency. We started the discussion a little bit a while ago on the brokerage relationship disclosure, but this is where you kind of get down to the nitty gritty, all right? The box right here is for them to initial that you did give them the disclosure of brokerage relationships. We know you did because we went through it, but they are going to initial right here. I do not know why this form came out with one initial here and one initial here. It should have 4 boxes, but for whatever reason, this particular form only has 2. Where it says permission to act as a dual agent will not be considered, or permission to act as a dual agent may be considered. This is obviously what you want them to sign. They are not agreeing to it when they initial. This is they're agreeing, again, just to consider it. And what you're going to explain to them is at the time you get agreement to buy and sell an offer from a buyer, before you present the offer to them, you will get their permission to allow dual agency or designated agency if the situation calls for it. Now, let me show you the forms. These forms, there are 2 separate forms, and you can give them a copy of it. I would not ask for them to sign it right now, because again, you just want them to feel comfortable to consider it. You're going to come back to them and disclose at the time an offer comes in, if it is dual agency or if it is designated agency. And at that time, they will sign these forms, all right? But it's okay if you leave them a copy. At least they know what to expect. Dual agency, you're probably not going to use that much unless you are an individual dual agent. You would have to use it. What you're going to use more is the designated agency, and that looks very similar to the dual. Now take note of right here. You see this? This is the seal of South Carolina. That means this is the lawmakers who have initiated this form. It doesn't come from the Realtor Association. It is a legal requirement to be used in this circumstance because it has the seal. It's statute, so it has the seal. So now if you're in a designated agency situation, the firm is the dual agent, remember, but our policy is if there's another Ballantine agent brings you an offer, you're the listing agent. Another Keller Williams Ballantine agent brings you an offer, you're going to go back to the seller and you're going to talk to the seller about the fact that you will be designated to represent only him. The other agent representing the buyer will only represent the buyer. That's designated dual agency so that your seller can feel confident that there would not be any conflict because you're going to represent him. If the seller does not have any problem with it, of you being on both sides, that's when you would use the earlier form, the dual agency. Most sellers want, or buyers want, their own representation. So our firm policy is that if the firm is a dual agent, each agent can be representing the client that they have the agency agreement with. Now, when you get that offer from the other Keller Williams Valentine agent, let's go to page 2 of this. Right here is where you're going to put, or the buyer's agent is going to put my name, because I'm the broker in charge of Keller Williams Valentine. It's going to be your name because you are going to be representing the seller. And that agent's name is going to go right here. Then they are going to fill out this section right here, let the buyer sign it, put the Keller Williams Valentine right in here, and right in here, the associate, the buyer's agent, can sign it. So when you get an offer, agreement to buy and sell, if it is designated agency, you must have this form to go with it so that everybody knows who's representing who. All right. Then when you, as the listing agent, receive the offer, this should be on top of the offer. This needs to be addressed prior to going through the offer, because if they don't agree to it, then you've got to go back to the buyer's agent and redesign the process of what needs to be done. We don't ever have any problem with this because they do what the sellers are happy to have you representing them. So that form should be presented to the seller before you present to them the offer. Now let's go back up here. So you can kind of explain that briefly, that you'll be bringing a form back to them. You can show them the copy of the form. You can leave the form with them, but you're not asking for them to sign the form right now. Right here, we go on to the terms. The terms, obviously, the number one thing the seller's interested in is how much money can you sell that property for. You're going to write, just like a check, you're going to write it out right here, again, in words. You're going to spell out the dollar amount. Right here is where you're going to put the numbers. Maybe you're going to sell it for $300,000. So right here, you're going to write 300,000. And right here is where you're going to put, and watch this word right here, the total fee that the seller is going to pay. The total fee for eons of years has been accepted as 6%, out of which you would come down here on the next page and you would put 3% to the buyer agency. Right down here where it says compensation to other brokerage, that is going to come out of this total. Do not put 3 here and 3 here, because you just gave away all your commission. Okay, so this has got to be total, and this is going to be anything that's coming out of it. Now, when you look at this section right here, this blank is the only one we compare that we are going to cooperate with. We do not cooperate on a dollar amount. That's a transaction type of service. We do not offer transaction brokerage, so that's a dash through there. We do not offer sub-agency. If you represent the seller, you are the sub-agent. The firm is the agent, you're the sub-agent. We would not let someone from another company come in and represent our client. So the only blank you're going to fill out is this percentage right here. We've been going through quite a transition in the last year or so as to the amount of money that would be considered the total commission. We rarely right now are seeing a 6%. More often we are seeing a 5% and maybe a 3%. You would keep 3% and you maybe come down here to 2%. The buyer's agents have more or less grown accustomed right now to seeing 2.5%. They really don't like it less, but there are some firms and some teams that are offering less. It's not what you would prefer, but they have the legal right to do it. So just be aware that you're probably going to have better response. Tell your seller if they will go to 5 or 5.5, which gives you some additional funds to do your marketing, and maybe you're going to do staging or doing some of the extra work, because listings are a lot of work. And particularly if you have an assistant that's going to be working with you. So when you have that discussion with them, there's no set amount. Commissions are negotiable, and they've never been more negotiable, quite honestly, than they have been in the last year, a year and a half. All right, so make sure you put a total here, and you're going to put whatever you're going to share with the buyer's agent here, and that's what's going to be listed in MLS. All right. One of the things you want to point out to is this little section right here. There's a blank here. That's the protection period. If for whatever reason your listing expires, then you're going to be protected for up to this many days. I always put 90. I mean, that's just what I do. I'm not telling you to, you can do 15, you can do 180. 60 to 90 is kind of typical, because what happens a lot of times is if the listing expires or is terminated, either the seller has decided not to sell, or they're going with another listing agent. And once they sign with another listing agent, your protection period is over. So you don't necessarily need to make it 180 days, because it'll be very unlikely that they're going to list with somebody else, that they're not going to list with somebody else during that time. But as you can see it here, the protection period shall be terminated if an owner enters into a listing agreement with another broker during that period. Let's scooch on down here. Memorize this thing right here that's in bold and caps. Memorize it. The earnest money, no earnest money is going to be dispersed under any circumstances until there is an executed, signed agreement authorizing the disbursement by all parties or by court order. Back in 2017, the lawmakers eliminated every phrase in this entire process of agreement to buy and sell that would make reference to who would get the earnest money in case of a default or a change of mind or whatever. There is no place in the agreement to buy and sell that says any money will go back to the seller. So your seller needs to know that earnest money must be agreed upon in an agreement by buyers and sellers, or there's not going to be any release, or it goes to court, which is the magistrate's court most of the time in South Carolina. Anything under 7,500, anything over 7,500 has to go to civil court. So, but keep in mind, there is no release of earnest money except by executed agreement by all parties or the court order. You're going to see that in a lot of the forms, but you might as well memorize it and let it digest in you too, because it's so hard not to want to say to a seller, well, if the buyer does that, yes, you get the earnest money. You can't say that. Okay, obviously, because it's not in the contract. Okay, right here is a list of the duties that that you expect from the owner, the seller. These are itemized pretty succinctly of what your expectations of them are. You've already explained to them your expectation, or they can expect from you a fiduciary relationship. You're going to fulfill your fiduciary duties. Now, these are the duties you expect from them. This little blank right here, make sure you put NA. I would highly discourage you from offering or being willing to take on the responsibility of paying any debt for a seller. Years ago, when like someone was in Vietnam, let's say, or they were overseas in service or wherever, and they may not could have paid the loan person, or they could not have paid the plumber who had to come out and fix a leak. And they would authorize the seller to pay for those on their behalf, and then they would reimburse the agent. Nowadays, there is no reason for you to do that. They have Zelle, they have Venmo, they have so many ways of conducting their own business. So I would say, don't take on that responsibility. Put an NA there. Let's go down here. Most of these others, I want you to go through and read them and be familiar with what's in the paragraph, but you're probably going to explain that pretty quickly. Excuse me, where that sneeze came from. The thing that I wanted to call your attention to right here is, remember a while ago when I showed you the October the 25th date, and we went over to look at the coming soon form? This is where you're going to show on the listing agreement that you're going to go with coming soon or active as public marketing, or you can choose an office or firm exclusive. Now, we talked about, and I showed you the form, if you're going to do it active or coming soon, which has to be done within 1 business day of that initial term date. If that's what your seller has agreed to, if you're going to put it in active in 1 day, or if you're going to enact the coming soon, this is where your seller's is going to initial right here. That's going to be the seller's initial. And look here, initial only 1 option. This is in MLS as active or as coming soon. And right here, it basically says that the owner agrees or does not agree that the listing will be placed in electronic marketing mediums, including but not limited to internet. If they do not agree, you can't really take the listing because you can't market it. Anything you put in MLS is going to go out IDX, which is electronic. So help them to understand, and it's to their advantage really, as to if you're going to market it, let's market it all over the place. So this is the initial way the most listings are handled. The seller initials here and checks here. Now, the other option is a firm exclusive, or they call it an office exclusive. And this would be your option 2. If you're not going to go public, this is the way you're going to be able to have that listing. You can have all 500 of our agents in Keller Williams Ballantyne to be able to market it to their sphere. They can't public market it. You cannot have a sign in the yard. You cannot put it on Facebook. You can put it in the Ballantyne, it's called Original Keller Williams Ballantyne, official Keller Williams Ballantyne Facebook that only goes to our agents. You can put a firm exclusive on that Facebook, nowhere else. All right. Our agents can show, they can sell that listing. If you remember back on the coming soon, the biggest thing that you've got to keep in mind is you can't show the property. Nobody can see the property. Yes, you can take an offer, but that person cannot see the property. In a firm exclusive, anybody, any agent in our firm, you or any other agent, can show it and can sell it. You just can't make it public. It was designed basically to take care of people who, for privacy issues, needed not to make it public that they were selling the property. It has been reduced to someone who really wants to handle it on an in-house basis. So, and what we're finding out as much as anything right now is the seller may not be ready to public market. So you can put it in a firm exclusive initially. And let's say in 6 weeks, the seller is going to be ready. They're going to finish whatever they're doing to get it ready to market it. Then what you do is you do the firm exclusive, but you must terminate the firm exclusive in order to then take it into active or coming soon. And the way you would do that is, let me show you. Number 12 right here. This is the other place if you want to put the pictures in it. Remember I mentioned a while ago, coming soon, no show status, seller authorization. If you're going to do it coming soon, you've got to note it. If you do the firm exclusive and not the coming soon, you're going to just put firm exclusive. But now we're going to terminate firm exclusive, then go into coming soon. So on here, you would strike through firm exclusive, initial that, and then add the coming soon no show. All right. You didn't have that in there because you knew you were going firm exclusive. If you terminate firm exclusive, just mark through it, and you can even write terminated and let the seller and you initial it. Then you either add coming soon to it or not. You may just go active at that particular time. So in that case, you would not need any change to the fact of it being firm exclusive other than marking through that, terminated, and that way you can go directly into MLS as active. Okay. In North Carolina, we have a form called 710. It's an amendment form. South Carolina chooses to have amendments done on the original document. That's why you're going to have it in that section. Now, let me show you the firm exclusive agreement. It looks very much like the coming soon because it is an MLS form. And this is the form. And make sure this is the new date is October the 22nd of the firm exclusive. And it explains right here basically what's going to have to happen in the firm exclusive. And this is where you see it in black and white. What I've been telling you, I have to sign it and I have to send it to MLS within 2 business days. Now look right back here. Here's your pattern of the order of signatures. Again, your sellers are going to sign it. Here's your name. This is a little different, but your name, you're going to sign it here. And I have to sign it within 2 business days of you taking the listing as a firm exclusive. Then I have to register it or submit it to Canopy within that same 2 days in order not to be in violation of the Clear Cooperation Policy rules. All right. The one thing that I asked for you to do on this form, other than to get my signature so I can turn it in for you, is right here. MLS needs to know, has the seller authorized you to put it in MLS as a comp after it has closed? You're not going to put it in before it's closed if you're just going to go firm exclusive. But MLS needs to know what the seller's decision is. Most of the time, they don't care after it's closed, unless it would be one of those people that need the privacy and says, no, I don't want it out there in MLS. It's maybe in the tax records, but I don't want it in MLS. All right. So just make sure this is either one of these is checked, and make sure you get this to me within 2 business days. Now that is if you're going to be firm exclusive only. If you are going to cancel or terminate firm exclusive, like I just showed you under option 28, then we would go back and do the coming soon form because we did this initially. Then we might go back and do the coming soon form, which you would get to me within 1 business day of terminating this one. Okay. And you're going to get it put into MLS. I know that can be confusing, but hopefully you can process some of that because you have some experience with it. Okay, let's go back up here now to the listing agreement. You have agreed here whichever you choose to do. This looks very, very similar to what's now in the North Carolina listing agreement. You'll remember the changes that came into that. So either option 1 or option 2. You must get agreement for the lockbox. I can highly recommend that you do the super box, mainly because, in particular, if the house is occupied, you want to know and be able to have access at any time of who has gone in that property. Yes, they're supposed to make an appointment, but every now and then there are people who disregard that, or for whatever reason, maybe they got in the wrong house. We've had that happen more than once, where there's a couple of houses in the neighborhood and they go with the wrong one. But you do have to have the agreement for a lockbox. And again, I totally recommend the super box. The combo locks are too easy for people to find out the combo. If nothing else, you're talking to showing time, you're writing it down, and the buyer is looking at over your shoulder and gets the combination. We've had 2 buyers in the years that I've been doing this who actually started moving things into the house before they actually closed on it, because they were able to get the combo code. I'm assuming my agent was telling the truth, that they did not give it to them, but the buyers found it and they were able to get in the property. So we don't want any of that. Okay. Sometimes you put a combo lock on a house for maybe a service person, a contractor, to be able to get in and do work. But otherwise, I would discourage a combo lock. Notice right here, other offers. The seller needs to understand that the broker's responsibility to present offers to purchase to the owner for owner's consideration terminates at the closing of the subject property or expiration of this agreement. If there is an offer that comes in before it expires, you are responsible to present any and all offers and present them promptly. All right. But after that, you are not responsible unless the agent calls you and then you call the seller and ask if you can continue to represent him. All right. Because then you're going to have to amend the listing agreement and extend it in order for this property to be shown to the buyer who hopefully, or the person who hopefully is going to be a buyer. Down here, these are basically things that you will talk to them about as you're listing the property. You don't have to read everything in here, but touch base on most of these so that they understand what their responsibility is. Photography. Make sure that they understand that the photography that's put into MLS does not belong to the seller, even if they pay for it. The photography doesn't belong to you, even if you pay for it. The photography right belongs to the owner, the photographer who did the video or who did the photography. There are some of the photographers who will ask you to sign a release form so that you know if they're going to claim that you have general rights to continue to use it, or if you have only the specific right for that particular property. Make sure to read any agreement that the photographer might give to you. I'm someone just the other day where another listing agent, and we see this sometimes with the rental agents, they will use the entire write-up. They will use all the photography from the listing agent. They can't do that. That is a violation. And if you were to have that, you're going to call MLS and report it to compliance so that they will take care of it with the person who is using the photography. But help your seller to understand that he doesn't own the rights to the photography, even if he sells for it, if he pays for it. This surveillance. This is a little different in South Carolina than North Carolina. As the seller agrees to abide by any laws and regulations regarding audio and video surveillance. In North Carolina, we are told that they can, and the seller can sit in the cubicle down in Bank of America or wherever and watch a video of somebody being in the house, but they cannot listen to an audio. They cannot tape an audio. This is something, it defines it a little different in this paragraph, but I would caution the sellers that they are not to be privy to the audio and the video from their surveillance equipment. Okay. Now, right here, this is what really concerns me. It says seller agrees that broker may or may not disclose potential surveillance. I do not know why they would think that. I do not know why. Excuse me, that was my mother. Why we would have to have their permission to tell about surveillance, potential surveillance. Most of them have a sign in their yard for one thing about the security, but then I don't understand that. But I would always try to get them to see the validity and the less liability of disclosing that you do have some potential surveillance there. But just be aware that that is different from your North Carolina contract. Again, we put here, well, the things that are going to be attached to this listing agreement, and I recommend the fixtures addendum at all times. And then you're going to do either one of these most of the time. South Carolina does not have an additional provisions contract addendum. You know, we have additional signatories in North Carolina, but what they did was they added extra lines on their listing agreement and their agreement to buy and sell. So you have 4 owner spots for signatures here. Even so, sometimes if it's an estate, that's not going to be enough, and you'll just have to add a second page to add additional signatures. Down here, you obviously are going to sign for the firm. You're going, and this mailing address, if it's different from the property address, you would add it here. You do want to have all that information for the seller available for us as the firm if we need to get to it. The firm name, and this is where you're going to sign for the firm because you're taking the listing, which is fine. Again, down here, you've got 4 spots for owners to sign, and don't forget to sign it for yourself. You'd be surprised how many we get in here where the owners have signed, but the agent has forgotten to take care of their side. So just make sure that you have that. And we have already talked about the fixtures addendum. So let's scoot on down here. There's that dual agency. We've kind of talked about it. The designated agency, there's your coming soon. And then you've got your firm exclusive. So now come on down here. Whoops, I hit something else. I guess I should stop and say, do you have any questions? I hope you know that anytime you do, please just come on, just interrupt me. It doesn't bother me at all. You okay?
I'm good. I'm sitting here just taking notes while you're talking.
Good. Well, like I said, don't be afraid to speak up if you are, okay? Now, in South Carolina, they also have a residential property disclosure that the seller is to fill out. In their form, it's called residential property condition disclosure. And a lot of times you'll hear a South Carolina agent who's been around the business there long, they'll call it the CDS. And I'm thinking, what is a CDS? And comes to my mind is CVS, because obviously that's where I go to the drugstore, but a CDS is condition disclosure statement. All right. So just so you don't get thrown off base like I do sometimes, it is their residential property disclosure. One of the things that's kind of unusual about this particular form is you're going to look, wait just a minute, get down here. You're going to see it was released 4/20/21. It is 1 of 5 pages. But when you pull the form up in your forms program, you're going to find 6 pages. And you say, what? Let me show you. So then when you pull it up, there's another page. But that page has no number on it. It has no one-off what. It's just another page. That's the addendum that is made available if there is an HOA that property is associated with. All right. So they did not want to include it in the property condition report. And so many people were missing it when it was a separate form that they packaged it together in the library forms. So when you pull up the residential property condition report, you will have this if you need it. Now, let's look right here and you'll see why they did it the way they did. They added this little section right here. If the property is associated with an HOA, then you're going to check yes. All right. And obviously the little asterisk says, if yes, the owner must complete the attached residential property disclosure addendum. Okay. That's why that little extra page is made available if it's needed. If you check no, then you just disregard that page, or no representation, the same thing. There is no reason whatsoever for anybody to put no representation. They know if they're paying anything extra for an HOA. They know if it's a voluntary or a mandatory HOA. They know if they're having to pay or not having to pay or suggested pay. There's no reason for a seller not to know that, unless it is a foreclosure or an estate. All right. Just like in North Carolina, there are some exemptions. And I think I didn't put that exemptions list in here. No, I didn't. I need, if you want it, I'll send it to you. I do have the list. Primarily, it is foreclosure or an estate, because an heir may or may not know anything about the property. A bank and a foreclosure certainly doesn't know anything about the property. So those are two exemptions. The other exemption might be where two parties that own the property. Remember, I told you they would be joint tenants, but they wouldn't be rights of survivorship. Maybe one is selling to the other. Well, obviously you wouldn't need a property disclosure in that scenario. Or if a family member, let's say a family, maybe the parents are selling to their child or vice versa. That's within a family, you wouldn't need. So, but I can send you that list. I should have put it in our file here. Just like we have the statute in North Carolina, we have the statute in South Carolina that says what's exempt, but just as a rule of thumb, no, it's an estate and a foreclosure. Now let's see. Let's go back up here to the top. Again, there are a lot of questions that they might not know. They should, and there's no excuse for them not to know about HOA. There sometimes are reasons that they would not know about some condition of the property, even if they're the current owners, okay, and they currently live in the house. So sometimes they don't know. This, I just kind of highlighted a few of the things to keep in mind, that if they say, yes, there is an issue, then explain it somehow, even if you have to add an extra page, but there are lines toward the end of the form here that they can disclose it. And you're going to hear me say it many times. If you're going to err on the side of too much disclosure, your seller is going to be so much better off if they say there was work done in the crawl space 2 years ago. And I would say invoice available upon request. You don't have to make it available to everybody. If they want to see what was done, who did it, whatever, they're going to ask you for the invoice. And that invoice then would suffice to give evidence of what was done. The seller is going to say, well, I had the work done. Why do I need to disclose it? It's fixed. I can't tell you the times it wasn't fixed. I tell you, it's amazing to me how sometimes people can get work done and it really wasn't done, particularly in the crawl space where most owners don't frequent very there. You know, most of us don't go back down in that deep hole. So in a crawl space, it is not guaranteed that the work has been done sufficiently that an inspector won't call it out. So you want to make sure that you have some invoices. If the HVAC was replaced recently, and you heard me say recently, sometimes they'll say, well, I have a new HVAC. And you say, well, that's wonderful. Do you have an invoice on that so we could, who did it and whatever else? And they're gonna say, well, oh, I can't find that. Well, when did you have the work done? Can you check your check register? Find if it is new, it would have, you really don't need to call it new if it's any more than about 3 or 4 months. All right. Most of the time people say it's new if they've had it the last 6 years. So you want to watch that word new, because when you advertise new, you may be buying new because you misrepresented that, you advertised falsely. All right. Even if the seller told you, you can still be in trouble. So you want you be the one who does the verification of this. You want to find out also, was the person who installed or did the repair was a licensed person. South Carolina requires licensed people to do repairs. They do not cotton to handyman doing it. Okay. So you want to make sure that you check to see if this work was permitted. You want to see if the work was done by licensed professionals. You want to see how long ago it was done, and particularly on the HVAC, watch carefully to see that it was a total picture of the HVAC. More likely than not, it wasn't the AC that was replaced, updated. The furnace is going to last a lot longer. And if you advertise new HVAC, you may be buying a new furnace to satisfy your advertising of new HVAC, not just AC. Okay. So be cautious of those things and be inquisitive. The seller doesn't know what to tell you. So you've got to ask, you've got to know the questions to ask to make sure that you are going to represent what he has represented or she has represented to be the truth, because you're then going to advertise it in MLS and other places as to what they've told you. Right here, you might want to point to this. If they do put no representation, the owner is stating that they're making no representation regarding the condition or characteristics, but they still may have a duty to disclose information that is known or should have been known. And unfortunately, as an agent, if you know it and they choose to check no representation, it is your responsibility to make it known. That doesn't cause a conflict in most situations, but every now and then it could. So you want to make sure that you understand and know the details of the condition of the property, again, because you're going to be advertising and verbally telling other agents what's in there. I'm not going to go through each one of these sections. I think it's rather interesting that the very first section on here is the septic or sewer and the water supply. And we have our own little in-house form of agent discovery. I can't tell you how much that has helped our agents. We've been focusing on this for about a year now. And I tell you what, we were spending so much money and our agents were in so much hot water because of the septic sewer situation. And then we've had a couple of situations that cost them money on the well or not being connected to city county. I can't imagine anybody choosing well versus city county, because normally that's what they want. But we actually did have one last year that the woman said, I said I wanted a well. I do not want city county. I want to be reimbursed, blah, 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 blah money. Oh, great. So use your septic or sewer and water agent discovery form to verify. It is so important that you verify what the seller has put on here. The seller is required to disclose it on here to the degree they know it. They should know. Sometimes they get confused. They think that their water bill is saying they have a septic. Not unless it's written on the water bill, it's not, and they'll always say, well, I pay my water bill and it has it on it. ask for a copy of their invoice. Now we're running into the people who say, well, I don't ever get an invoice. I don't get paper. I just have it automatically set up to draft my account. Oh, no, so that's when, again, you have to call and find it out. So you use that agent discovery form along with what you see they have disclosed right here. The types of pipes, a lot of times they will not know what the type of what the pipes are. You don't tell them what type they are. You can just explain why they ask about these different ones. And if they don't know this, then obviously check here that they don't know. More than likely, if it's a house that's about 8 or 10 years old, it's going to be a PEX piping of some kind. It could be a polybutylene, but those were done probably 20 or 30 years ago. But again, if they do not know, they put unknown. That is not something that you have to research. The inspector, home inspector will point that out. This was added to the property condition report more recently. I think it was the last version about the roof. You want to know the year or approximate year the current roof was installed. You want to know the age of the structure. If the house was built in 1999, if there has been no change to that roof, then it's going to be 1999 here and right here. If for whatever reason your client knows of any changes or any leaks or whatever, this is where they're going to put it right here. They're going to disclose right there. That's where I would again ask for an invoice. Could they make an invoice available, or could they at least tell you who did the work? Maybe you could call back to that vendor and get the date that it was done, or an invoice if the seller doesn't have it. I'm not going to go through a lot of these individually because obviously you're familiar with some of them, but just be cautious when an owner doesn't know the answers to some of these things, or you might can kind of discuss what it might be, but you don't put pencil to paper on this. This is the seller's disclosure, but you are responsible for verifying a lot of it. I just mentioned a moment ago about the building codes and permits. Building codes and permits this year has been, I can't tell you how it's been magnified in North Carolina. We have not seen it on the South Carolina side as much, but nevertheless, be aware if there have been code violations, or if there are codes that they've been aware of, or if they have done work and have the permits. I think we see more of the easements and encroachments, which if they have a survey, you want to ask if they do. Obviously, the buyer can't rely on it, but it gives you the understanding if there is an easement, which is very likely there's going to be a utility easement in a lot of these developments. Make sure that you know if there's an easement. You may not know of an encroachment. It could be a fence, it could be a storage shed, and maybe the seller knows and maybe the seller doesn't. You're not as responsible on the encroachment, but the easements you should know. Right here, flood insurance. The seller should know if they pay anything extra in the year for flood insurance. Flood insurance is not like your homeowner's insurance that's paid every month. It's paid annually. Flood insurance by and large comes from FEMA. It is not excessively high, but at the same time, if the property, the residents own the property, is in a floodplain, flood insurance will be required. If the floodplain goes across portion, let's say of the backyard or the side yard, flood insurance will not be required. However, the seller may need to have an elevation certificate issued by a surveyor to confirm that. But just while the seller is filling this out, knowing whether or not he pays or she pays flood insurance is all this report is asking for. This year of the Department of Motor Vehicles if there's a mobile home on the property, it would be registered with the Department of Motor Vehicles. It's a VIN number, VIN, vehicle identification number. That is something that has to be what they call de-titled. It has to be changed from the title being with the Department of Motor Vehicles. It has to be changed to it being a deed, and you have to get it de-titled with the DMV, or you can't sell it, because we can't sell automobiles. We can't sell vehicles that have a VIN number. We can only sell real property. And if the mobile home is attached to the property, then it should be de-titled before you can sell it. And again, that's something to call attention to it. I'm not going to go through too much more of that because you always can read those things. There's that addendum statement that this is just if there is an HOA that's involved with that property, you need to get all the information and make it available to any prospective buyer. And the seller hopefully will be able to identify here what it covers. If if the seller doesn't know and you don't know, try to get in touch with a property manager or someone who would have a better knowledge of it. Sometimes these property management companies don't want one more person to call them, but do your dead level best, because you obviously want to put the right information out there. Again, this is going to be signed by the owners here, and the purchaser is signing here. Here's your flood insurance disclosure. We were just talking about that. You can use these websites to look up and see if they're all consistent, if they're all saying the same thing, the property is or is not in a floodplain. Just be aware that these maps do change periodically. They won't be the same 20 years ago as they are now. So when you are doing the listing, you want to definitely verify that with one of those. And you want the seller to know that you're going to verify it. Then the buyer's agent would give this to the buyer as well for the buyer to sign. The seller has already put it in the disclosure that we just went over. Now this is where the buyer says, I have looked at it, I've checked it out, and I know about the flood insurance. If your property, and you'll see in a number of these, particularly if you're going to be selling down in Sun City. I had just the other day, one of my agents who sells a lot in Sun City, and I don't know why, I don't know how she got caught on this one. She sells a lot in Sun City, but the CMLS checker sent her a violation notice that she had not turned in this 55 and older statement of qualification. And she's saying, everybody knows that Sun City is a 55 and older adult, active adult community. Do you know MLS requires this form on every single listing? There may have been 10 listings go in that day from Sun City. Every single one of them has to have this form filled out. And looky here, it has to have a certifying party signature, and it has to have a witness. Okay, the witness can be the listing agent, but you have to have somebody from Sun City that will sign on their behalf. And yes, it's in their bylaws and everything, but MLS says that could change any day. And so therefore, every listing, if you list something in Sun City, or Four Seasons as another one, there, of course, many are being built right now. Carolina Lakes, there are so many new adult, senior adult communities, 55 and older, whatever it's called. Make sure that you know that has to go into MLS along with the listing. Now, this is the form we were talking about a moment ago. It's your agent discovery form. And when you are double checking on this water and you're checking on the sewer, the reason I have both of these on here, Sometimes it may not be connected because the owner chose not to connect it when the lines were available in their community. It may not be connected, but it can be available. Well, the fact that it's available is very important to a buyer. If it's not connected, then it can be connected. Does that make sense? So you want to know, not only is it connected, or is it available? The same thing for the water connection as well as sewer. You will more than likely find a water connection available before the sewer connection. Somehow that kind of lags behind. So make sure that you call the county that the property is located in and find out if it is available, is it connected? And when you do, you want to put the date you called, the person's name, and most of the time they'll only give you their first name, get their name. And right here is where you write, let's say, Union County Public Works, or it might be Mecklenburg County Water Department, you know, whichever department you called, you want to put that name right there. Do not put seller. You've just nullified the effect of the whole agent discovery. Okay. I had one agent put seller and I'm going, oh, I can't believe he did that. You will rarely have a community service. There are very few neighborhoods that still have the community service. Danby down on 521 still has the sewer, community sewer service. In Kannapolis, you will find that the service up there is a community service. It is not a private service, and it's not city county. After about 2 weeks of searching and trying to find out what was going on up there, we did discover that in Kannapolis. More times than not, if it does have a septic, you need to find out from the environmental health department. Whoops. The environmental health department of the county where the property is located. If it's in York County, you need to call the environmental health services. You don't call the water department, find out about sewer service. You've got to call the environmental health department. Now, we are told that a lot of permits are not available that are older than 6 years. I have recently been told, contrary, septic permits are to be kept on file and available throughout the life of a septic. And I'm not sure exactly what that means, but it certainly doesn't mean 6 years, 6 months. I mean, 6 years. So question that with the environmental health services to see if they have a permit. If they say no, they don't, that's all you can go with. You can question whether or not there's a way that they can check microfiche or something. Most of them are not going to go to that trouble. So again, you want to identify who you talk to, right here, the name of the person you talk to in the environmental health department in whatever county and on whatever date. This is to show that you did your job in trying to find out. And if they would not make it available, you've gone as far as you can go. And if you are the listing agent, you're going to sign right here. That signature basically is you verifying that you've checked out everything on that on this sheet, and you don't need to go any further. You can, that way you know how to advertise it in MLS. You know how to answer a buyer agent's question. In here, let's switch gears a moment. If you happen to be the buyer's agent, however, you do want to sign here, and you do want to get the buyer to sign that you gave this form to the buyer. Okay, again, that would be if you are the buyer's agent. You can't require any other buyer's agent to do it. But if you are the buyer's agent, then you would sign here and get the buyer to sign. Otherwise, you are just signing that you verified what the seller has already disclosed. This is an explanation of what I just said. Professional services disclosure, you will see that it looks very similar again to the North Carolina professional services disclosure. We've had so many issues with an agent ordering a service for a seller or a buyer. And then that client says, well, I didn't tell you to do that, although they probably did, then that makes the agent liable for that particular service. In our required forms, we do not require a professional services disclosure from the seller side. There's very few things that the seller has to get a service on. All right. The service disclosure is primarily for the buyer. So we do require buyer agents to get the professional services disclosure, not the listing. And today we're talking about listing. So this would not be a required form. I would say it would be a good form for you to let a seller see that a buyer could potentially ask for any of these inspections or any of these services to be done, so that the seller, if they're not experienced in selling, they need to know what's to be expected. You're kind of setting expectation for them. Okay. The one thing I want to point out to you, the thing on surveys, if a seller has a survey, great, you can share it, but make sure that the buyer understands that survey is not to be relied on. They need to get their own survey, but it certainly gives you the information, particularly, as I said earlier, about easements and possibly an encroachment. Okay. And home warranties. We're not seeing home warranties as much right now because the market's been so hot that was one of the things the buyers didn't ask for. But I think we're going to start seeing them more and more. But remember that if the seller agrees for a home warranty, you can order it for the seller. You can put it on the property, and the seller will not pay for the home warranty until closing. It's a real good marketing benefit to a buyer. So you might encourage the seller, because the seller has the same benefit of the insurance policy, the home warranty, as a buyer would after they close. The seller has the benefit of it until it does close. And if it doesn't close, then the seller is not out any money. So a home warranty for a seller, I think, is kind of like a no-brainer. And while I'm thinking about that, there is a insurance called Seller's Shield. Now, I don't work for Seller's Shield and I don't get any kickback on it, but I often would recommend to a seller this Seller's Shield. It's an insurance that if your seller fills out the residential property condition report online with Seller's Shield for $199, they will stand behind that. If there's any legal problems with that residential property disclosure, their attorneys are going to handle it like any other insurance company. I don't think that's a bad idea. So think about it. And if it's something that you want to recommend to your sellers, we've got some information we can pass on to you, or just look up sellershield.com. I have seen so many legal problems on the residential property disclosure that makes me tend to think that insurance might be a good insurance. Okay. It's kind of like a cancer policy. You don't really want to think about it, but you think maybe if there's a good insurance, that might be a good one. So just be aware of that. Let's come on down here. The security system. Most security systems now are built in. There are very few that can be taken out that doesn't leave a hole in the house. So most sellers are going to own the equipment. They might not own all of the accessories. So sometimes there's some things added to the basic equipment that can be removed. But what you want to, this is again an in-house form. These are worksheets to help you to know what to talk to the seller about and get the answers, because you're going to be answering some of these questions to a buyer's agent. If there is additional security accessories, get the seller to find out about it. You want to make sure that the seller discloses what the fee is on a service contract. See, it's the service contract that's causing the problem. And the reason you want the seller to do this checking out is because if the buyer does not assume this contract, the buyer chooses what CPI is at ADP or vice versa, then the seller has to pay the penalty of getting out of the contract early. Let's say the seller hasn't had it the 5 years that the contract says that they have. The seller could owe, as one of my sellers did a couple of weeks ago, $785. Well, that's a lot of money when you're going to closing and you weren't expecting it. So you as the agent are going to make them aware they are responsible to get the details and work things out with the security company. You're not. That's not something that you need to call the security company about. I don't think they'll talk to you, first of all, but only it's the seller's contract. It's outside of the house, just like they have internet service that they pay for outside of the house. All right. So you are making them aware that they could be liable to have to pay off that service contract. Has nothing to do with the sale. It has to do with the timing, that if they don't move that service to another house and the buyer doesn't want it, they're going to have to pay out of it. So that's what that form is all about. Okay. And we are at the end of it, and I'm going to give you a time to ask a question if you want it, or you get an extra 20 minutes on your life today, because we're kind of at the end of our forms. What questions can I ask for you? Answer for you.
I actually don't have any questions.
Oh,
This
good.
was just definitely all a refresher for me. So
Good. Well,
Yeah.
that's good that you had some basis. You know what's amazing, how much you do remember and how much you learn or are
Right.
reminded of going
Yes.
through it. But
yes,
I'm so glad you joined me today. I'll email this over to you so that you'll actually have the forms we went through
okay,
and add that exemption form too. But
okay,
again, thanks so much for being with
all
me.
right.
And
Thank you,
next week
Sheba.
we'll be doing the South Carolina buyer forms. Okay.
Okay, all right.
I'll see you
sounds
next
good.
week.
All right,
Bye,
thank you.
dear. Have a
Bye.
good one.
You too. Bye bye.